Okay, everyone who's listening on the internet, my name is Ken Vercammen, and I'm an attorney close by Edison, and I'm here as a volunteer to try to educate people for about 30 minutes or so. The 50 or 60 people that are in the room, you can raise your hand. I'll try to answer any of your questions. You know, we kind of start off though, like a lot of times people see me at my Elks Club or American Legion around town. Kenny, why do I really need to have a will? I'm married, doesn't everything go to her? He goes, well, if it's your first marriage, yes, but that's not doing planning. They're just hoping that one of the two of you lives forever or 150 years like those big turtles. You know, part of doing planning is to try to make it as easy as possible for your family and having them have less aggravation if someone passes away. So if someone passes away without a will, or the surrogate will not accept the will because it was improperly signed and improperly prepared. Right? They'll talk about, they always say, don't use those cheap things because people do it wrong. Well, number one, the procedure to distribute assets becomes much more complicated. You know, someone could have 3 kids that all get along. It still requires them to agree upon who's going to be the administrator. The person who's not, the people who aren't going to be the administrator have to sign this paper renunciation affidavit in front of a notary and pay money to have it filed. And that's for people to get along. A lot of times there's some troublemaker kid or whatever that says, no, I'm not signing that. Well, then you got to go in front of, file a complaint order, show cause, go in front of a Superior Court judge. And we love our judges, but the cost of going in front of them between court costs and legal fees is always over $3 grand. Having a will costs substantially less than that. Number two, if there's no will, the person who becomes the administrator has to take out a thing called the surety bond. That costs about a year and you have to be bonded. It's like an insurance policy that you'll do the right thing. Most people, I tell them, it's a waste of $1,000 because if you trust the people you're letting handle your estate, wouldn't you rather have them have the $1,000 than some insurance company? There's more work that becomes involved, and for people with minor children, a total stranger determines who gets custody of children. You know, the bald white guy at the courthouse, the probate judge. So, you know, it's funny, the people have minor kids. Oh, it's a real difficult decision. He goes, no, it's an easy one. Who doesn't want to have your kids? And there's not too many people on the planet that, so and if someone says, I can't really, I goes, okay, listen, let's say you couldn't leave this room for 2 weeks. Who would you trust watching your kids? I guess my sister, my mom. Okay, good. And but the most important thing is when there's no will, it often causes aggravation and problems amongst the family, sometimes lawsuits. So when people are grieving, there shouldn't be one more thing they have to deal about. So think about, okay, who do you want to get your stuff? Who don't you want to get your stuff? You certainly don't want to have the government get it. If someone's leaving some money to grandkids, you want to have something set up where they don't get the money outright when they're 18 or 20, because how many 20-year-olds would spend money wisely? Zero. Let's say the kid could be the valedictorian of school, but they get influenced by their quote friends to go and spend their money. And the surrogate in their presence, we did a program last week and the surrogate was there, and the county surrogate said, listen, beware of these online things because we see over and over again, they're not done right, and people thought they were saving money, but instead they're just creating more issues. Okay, so believe it or not, one of the things that we try to make the procedure for doing wills and estate planning easier. The old system was very inefficient. The person would call the law office, schedule an appointment if they're working, have to take a day off of work. Then they'd be in the reception area filling out stuff that no one could read the handwriting. And so nowadays, for most people, that either they have email, their kids have email, and they can think about, and also you can think about it ahead of time. Because I've had people, when they're in our office, they're arguing over stuff because they hadn't decided ahead of time. Well, I can't be the mediator. I can prepare the document. So, and we email out the will questionnaire, and someone types up. We don't ask for any confidential information on your assets or your accounts. And then I call everyone. The great thing about having the iPhone now connected to the car is I can I can like have the steering wheel and say, call this one, call that one, and and I'm driving safely. Um, and then people can even pay for things like online. Other people says, listen, I'll send you a credit card, and sometimes the only time we see anyone is when they sign. And but 80% now are just saying, listen, I'd rather just sign over the weekend at the UPS store or a notary, so I don't have to take a half a day off of work. So what's some of the stuff that you need to that you're going to type in? Well, you're going to type in your name, and you're going to type in who's executor one, who's executor two. You don't want to have joint executors. Now, it creates more work for them. The reason they could be twins living together, but when it's joint executors, that means that two people have to go to the surrogate's office. Two people then have to go to the bank to open up an estate account. Two people got to sign a listing with the realtor. Two people got to sign a contract. Two people have to go to closing. Two people got to sign every single check. That is not making it easier. I'm involved with in a matter now. It's joint executors, and I said to the brother and sister, I goes, hey, listen, you guys, it's great because you guys get along so well. It make your life easier if you can if one person says renounce, let the other person do it. He goes, no, we want to do it together. Okay, well, the fellow works a second shift and they can't get together, but that's it. It's already in there. Again, the reason why you don't want joint, those are people who get along. You sometimes have people that don't agree, don't like each other. I handled a probate contested case. One brother would say the sky's blue, the other one would say, no, it's gray, you're stupid, you've always been stupid. And this is the kind of stuff they're saying in front of the judge. And the judge says, fellas, why don't you guys go and have a cup of coffee? You had some fun times when you were kids, come on. Okay. Believe it or not, New Jersey did away with one of the taxes. They did away with the New Jersey estate tax. So except for like that lady, but there is a tax. But it only applies to like, let's see, that lady right there, because it only applies to people that have more than $12.5 million. And all the rest of people with only $11 million, you don't got to worry about it. We do ask what real estate you have, because some people might have a second home in the Poconos or in another state, and that means that there's another process when they do it. But because New Jersey did away with the estate tax, I just say, hey, your assets, ballpark, more or less than $12 million. Let's see, don't need anything more. Then you're going to indicate, okay, who's your beneficiaries, and if that person passes, who would get that person's share? You don't want to have anything dangling. You want to say, okay, what if this? Then who would get it after that? I'd say more and more people are not leaving the money to kids; they're leaving it to grandkids. Your own kid, your own kids may be like grown up, have their own house, but your grandkids have college like looming in the future, and college is going to be $100,000 a year. And it's your right to leave your assets to whoever you want. You can't leave a spouse penniless, but other than that, you're able to do what you want. We did a will for a little old lady in North Plainfield, and she didn't have any living relatives anymore in New Jersey. Her husband was passed, her sisters were passed, and no kids. And she had cousins in California she hadn't seen in 30 years. She left something to her hairdresser, some of her neighbors that were nice to her. Last year, a lady goes, she had 4 kids. She goes, do I have to treat all my kids equally? One of my sons lives on the West Coast. We don't hear much from him. Okay, let me ask you a question, Gilda. Did you get a card or a call on Mother's Day, your birthday, or Christmas? She goes, no. Why would you leave that guy anything? Leave it to the people who care about whether or not you're alive, rather than are the first person go running in once you die saying, where's my money? Let's see, some people in second marriages, like instead of giving it outright, they set up some kind of trust for the spouse. People occasionally do what's called a specific bequest. They may say, hey, I'm leaving some money to a particular charity, or like, 10,000 each to grandkids or whatever. That, again, that's your right. Some of the ladies say, listen, any jewelry I have is gonna go to my daughter, my granddaughter, because if my son's the executor, he's gonna bring it to Cash for Gold and say, what do you give me for this junk? That's it. Some of the men, like, were sportsmen, they got firearms. Okay, it's gonna go to this family member that's also a sportsman. Some of the guys have their, we thought that all of our old baseball cards were worth something. No, they're not worth much at all. I talk about specific, it's stuff that is worth something. Then we have what's called the reverse specific bequest. I leave nothing to name a person. I'd say you don't leave them $1, you don't give a reason, just nothing to them or their family. And one of the things you're buying, people talk about, can someone contest the will? Yeah, they get paid the money, contest it. But when you have an attorney prepare the documents, you're also buying someone that, if their issue ever came up, can say to the judge, listen, I spoke to the person, this is what they told me they wanted, and that's just how we prepared the documents. We're involved with an estate matter for someone that I knew for 30 years, and he was sick. We prepared the new will, and his one daughter was written out, and she filed a caveat, a challenge to the will. And we were at one of our conferences. I said, Judge, listen. He goes, I knew Ed M. I knew him for 30 years, and I did all his wills. And for the past 20 years, she was never in because they did not have any kind of, the only relationship was not a good one, because she would, whatever she said would stress out, Ed and his wife. So again, it's your right to do what you want. Some people set up a testamentary trust within the will for an adult because they could have drinking problems, alcohol problems, spendthrift, owe everyone money. That way a different family member has. I'd say logistically, we prepared a will, and I email out a draft to everyone so they can read it. And we're trying to be environmentally friendly. By the way, we're talking about assets. Certain assets don't pass under your will. They go automatically to whoever the beneficiary is. So example is, if Hass's own husband and wife, automatically goes to the survivor. Will can't change that. You have bank accounts, let's say, and it's payable upon death, POD, joint tenancy, automatically goes to that person. A will can't change that. Other assets passed by contract, IRA, 401k, life insurance, annuity. The will can't change that. So if you put down someone as a beneficiary, but your will says split 3 ways, whoever was put down as a beneficiary gets it. Okay, I'd say also, have a professional do your stuff. Attorneys might make a whopping $400, $600 on doing a will, but when you don't have the stuff, then it's going to cost more. And by the way, some of these people want to read up on stuff. They say, I'd like to read more. I go, Carl, you don't need to read anything. Listen, I went to law school, I passed the bar. I've been lecturing on this and speaking on this for 35 years. I wrote a book. I'd say, you're an engineer. I'd say, if I need an engineer, I'd say, I'll call an engineer. And I'm not reading about how they're engineering stuff. When I had my knee surgery, I didn't want to know how the doctor was going to do it. He goes, you can watch it on the screen. I don't want to watch that stuff. Knock me out. By the way, I always say, typically attorneys charge a consult fee. Just if someone wants to chat, we charge a $200 consult fee. But if someone contacts us within 30 days, we don't charge them a consult fee. All right. So we've been talking a little bit about wills, and only the original will can be admitted to probate. So after you sign your document, you want to put it in a place where your executive can get to it. Most people just get a fireproof box and put it under their bed, which is the dead zone. That it's nothing's looked at until the house is being sold. It's a big wide, it's fresh carpet filled with a lot of dust. Well, less dust now that they have those robot vacuum cleaners that are good, because they go back and forth. I love them. I love those. If I had my vacuum, those robot vacuum cleaners running 24 hours a day, it still would not pick up all the dog hair that's in the house because I got a big yellow lab. Okay, let's talk about trust for a second. I remember my mother-in-law would call me every other year. Oh, I want to come in and get a trust done. And I would say, were you watching Susie Orman? She said, oh, yes. Susie Orman is so right. If you live in New York, California, Florida, where the probate process, is very complicated. It's costly, like $12,000, $15,000 more. It takes a long time. New Jersey is the probate easiest state. So whenever someone says, I want to have a trust done, I'll ask them, why do you think you need to have a trust other than Susie Orman says, it's a good idea, or your friend who lives in Florida? I'd say, because probate in New Jersey is easy and inexpensive. There's no reason to spend between $3,000 and $6,000 having a revocable trust. A revocable trust does not protect assets from nursing home or Medicaid or from taxes. Some of the salespeople talk about, oh, a trust is a private document, it's not a public record. He goes, well, do you really care if people know if your will got into probate, who's getting your stuff? And most people are giving it to their kids and not to someone that you wouldn't want to know. And also, so if you have a house, it's not going to be owned by you anymore. It has to be retitled, new deed, etc. Now, for the purposes of Medicaid, that's what's called an irrevocable trust. And with an irrevocable trust, basically, the assets are retitled. They're not owned by you. They're owned by the trust. You're not the primary trustee because you can't have the full discretion. And it has to be 5 years before you apply for Medicaid. And it's very expensive. But if someone's a gambler, he goes, okay, the cost for the having one person having a trust, they might the trust people might charge $5,000, but that's half the price of 1 month in a nursing home. So it's kind of like people got to decide what they want to do. And for the people listening on TV land, the people that are working full time, many of their companies provide insurance coverage where it's similar to eyeball coverage and health. It covers lawyers, estate planning stuff. So the three main companies in New Jersey that companies have, one is MetLife Legal Plan, the other is ARAG Legal Plan, the other is Legalese Legal Plan, and some of the retired Ford and GM workers have the UAW Legal Plan. If someone has children, grandchildren that are receiving SSI, SDD, special needs, we don't want to give them money outright because they might lose their entitlement. So that's why it's important to let your attorney know about that early on before doing stuff. Okay, so before we go into the power of attorney portion, does anyone have any questions on wills? Okay, let's talk about powers of attorney. A will takes care of your assets if you pass away. What a power of attorney does while you're alive, you're giving the power to someone who you trust to be able to make to do your help with your finances. And you had a question, young man.
Yeah. I want to break you guys. Do you need an executor for the will?
Yeah. The will has to have an executor because once you pass, who's going to be the person that distributes the assets? And someone says, I can't, and it doesn't have to be someone in the United States, and it's better. Our rule of thumb is the person who's the executor should be someone that can drive to the circuit's office, drive to the bank, and write a check. Sometimes, someone said, I got someone that, I tell people that when their parents are older, over 80, it goes, does mom and dad still drive? No. Well, listen, I'd say it's gonna make dad feel sad, but it doesn't make sense to have dad as the executor on mom's will because he can't drive and do the stuff. Where I try to be as practical as possible, because I've been doing this for a long time.
Can the executor be also part of the will? I mean,
yeah, they can get
money. Be beneficiary.
Yes, sir. Yes, sir. Hey, Assistant Dan, this gentleman asked a question, so he gets the book War Coins for Seniors.
Next question.
Yeah. Yes, ma'am.
Okay. After the deceased dies, which takes precedence? The debts of the deceased or the executor's fee?
Debts are paid first. Debts are paid first. And there's no executor's fee if there's not assets. So, for example, the debts are always paid. You know what? The primary thing is funeral gets paid. There's a hierarchy of which gets paid first. Let's see. So funeral related stuff gets paid first, and then all the debts. No one gets any money until.
So the executor cannot get their fee if there's insufficient
If there's no
funds
money.
to pay the debts.
Yeah, and that's what I usually say to people. You know, I was on the phone with someone recently. He goes, okay. They said he hardly had anything. Well, what does hardly mean? You know, and they're talking because he was also he was in a hospital for 2 months and got discharged. He goes, listen, you know, well, he goes, I think that most of it's paid by. I said, my advice to you is do not go to the circuit's office and probate the will. There's no law that says when you got to go. My suggestion to you is wait a couple months to wait for the bills to roll in to see what insurance is going to pay. You don't want to buy yourself aggravation by becoming the executor of a bankrupt estate, because then they're going to be hounding you for the money. So I tell people, hold off and wait. Okay.
That's another thing I wanted to ask you. When do you say, what is your net worth to be when you say, you know what, I think I better go get a will?
Say it again.
What would your net worth be? You know, is there some, threshold where you say, okay, I don't need a will, but oh no, I need a will?
Yeah, if you don't have a will, I'd say it really depends on who your beneficiaries are. So if someone's married, I started to say if someone's married, it automatically goes to spouse. I'd say if everything is jointly, but there's always stuff that doesn't have a beneficiary, always. So in reality, it's usually us guys that pass first. So usually then the wife and one of the kids comes into the office and I goes, was there anything that was just in Al's name? No. And I go, what about the car? Oh, the car was in his name. And some other accounts that he had with work or whatever. I goes, well, then he got to go through probate. But if the answer is no, there was nothing, I goes, okay, then I just saved you the $160 surrogate filing. Nothing you got to do. Yes, ma'am.
We have a couple questions from home.
Okay, go.
The first one is from Gina, and she says.
I don't need no names. They're secret.
Okay. She says that she has a special needs child that will need care when she's gone. How does she go about setting this as replacement? This is the reason she's looking to make a will.
Hire an attorney that specializes in special needs trust.
Okay.
That's the really quick question, because it's kind of like, unless it's done right, you kind of ruined it for them. And the law changes all the time, because Medicaid is the same entity that pays for nursing home, that pays for everything else. If you get inherent money, they goes, okay, good, you're off, and then you got to reapply. Next question.
Can you have one executor, or do you need two?
Well, it's foolish to just have one, because if that person dies or can't do it, then you got to go in front of a judge to have the judge appoint someone that's called the administrator CTA. And going in front of judges costs money. Now, I've had people that says, Ken, I got no one on the plan. I got one kid, and I got no one else. I goes, well, who's getting your other stuff? Different charities. I goes, well, again, you don't have a friend that would be willing to help you out and get the commission? Well, I'll talk to him. I goes, the commission is 5% of the first $200,000, 3.5% after that. So I goes, okay, if your estate's worth $400,000, they're going to get 15 grand without having to do a lot of work. I wish that someone called me up every day to say, listen, I want you to be the executor, so I would get money. Now, ethically, I am not allowed to put myself, in the old days, the attorneys would say, oh, well, it's standard practice to put the attorney in as executor, which was a scam. So the ethics, people says, no, that, it's inappropriate, just put yourself in. If you have a relationship with someone. So, and I don't like, I only do it, sometimes someone says, I don't got anyone to do it. One fellow said, he goes, okay, my son's 16, he can't do it. My ex-wife, if I passed, would take the money that's supposed to go to my son and go on trips with her new husband, and my son would get screwed. You at least would make sure that, so until the guy became of age, I was his executor. And I got other people that are known, I get, I've been around in the Edison area, and they, if someone goes, I knew you when you were this high in St. Francis, so I think I can trust you. Next question. Okay, good. Okay, cool. All right. Let's talk. Oh, yes, ma'am.
Okay. You talked about minor children. If you want to leave.
Well, grandchildren. Yeah.
Well, grandchildren.
Yeah. I mean, you have like a whole bunch of minor cases.
I have 2 minor grandchildren. Now, if I wanted to leave money to them, but do you have to specify an amount?
It can be an amount or percentage, whatever you want.
Yeah, but like I'm living off that money. So
Well, that's what, but you're still,
they
you're
don't have anything
well,
left.
so that's why sometimes it's better to put a percentage than an amount.
Percentage?
Yeah,
Okay.
because if someone had, let's say they had, I'll use where they had 300,000 total to their name. Okay, 100 grand to this grandkid, 100 grand to this grandkid, and then divide amongst the other ones. Okay, they pass away, and they use. Hey, it's your right to spend all your money and enjoy it. Not worrying about them buying a gold-plated casket or whatever. All of a sudden, there's only 50 grand left. Well, the grandkids would have to split the 50, and the other people would get nothing.
Right.
So that's why some people just say they put a percentage, and we put a clause in that says they don't get any money until they're 21 or 25, but the money can be used for education, maintenance, support.
Right.
But they don't get the money. But it's up to the executive to decide, where they're, to use it.
Well, they're very young. It's just
Yeah.
8 and 5. So,
So that way.
because I would probably make my daughter the executive, but I don't want to give them all the money. I want some to go to the grandkids.
Yeah,
Do you
so
have to
that's-
specify
You
when
can-
they become a certain age?
Well, you don't get it until you want to have it until they're an adult. But it gives the executive the discretion to advance money sooner. So, for example, okay, kid gets accepted to private school. Like I went to University of Scranton in the 1970s. It was relatively inexpensive because that's how it was back then. And then, the different priests were teaching. Now, the regular lay people, are making big money. So it's, $60,000 a year, whatever. So, some people say, listen, it's going to go in the discretion of, the executor to use it for college or whatever else. But that does not mean trips to Disneyland, Disney World.
Now, you would also have to change it in the beneficiary, because like right now, my daughter is the beneficiary.
Yeah, so
for everything.
remember I said, if your accounts have your daughter as the beneficiary,
Then it'll all go to her.
it all goes to her,
So I
so
would have to change
you
that.
have to change that
Okay.
and, on that. Okay, I gotta talk faster. Let's talk about power of attorney, okay? The will takes care of your assets if you pass away. What the power of attorney is you're giving the power to someone that you trust, typically a family member, to let's say you fell and you broke your leg, to make sure your bills are paid and that your finances are taken care of. And listen, even if necessary, to sell a house or do whatever needs to be done. I'd say, but the power, you want to do the power of attorney while you're well and can think, because we get a call twice a week. Oh, I need to get power of attorney over mom, dad, or Uncle Joe. Well, you can't get power of attorney over anyone. They have to affirmatively, give it to you. And for us to legally do it, I I gotta talk to them and they gotta say, okay, who's the number one, who's the number two? Do you want to have a power of attorney? Yes. What do you want to do? I want them to be able to do my stuff. Okay. And now, not every person has a computer and can type good, whatever, especially if they're, but, that's why there's like children and family members that can help them out. So this way, if someone types it up, and then before I can prepare the document, I said, I need to talk to them first. Well, this is what they told me. That's fine. I need to talk to them first. Now, when someone does ask about having the power of attorney, especially for someone who's like, hospitalized, etc., it goes, can they talk to us over the phone and say what they want? Yes or no? And another fellow, I goes, and do they read and write English? Okay, yeah, because I can't do a document for someone that doesn't speak my language because, this fellow says, my dad also needs a power of attorney, like, and a will. And he goes, he doesn't speak English, but, I will translate for him. Okay, how many kids are there? 3. Does he want everyone treated equally? No, he wants everything going to me. Sorry, can't do it. Sorry, can't do it. I mean, I don't do anything that's going to jeopardize my license and my career, my reputation. I worked very hard for stuff, and we kind of have to. If it smells bad, we're not going to do it. Let's say, us guys eat just about anything that's in the refrigerator when we're hungry. But if you open up the container and don't smell good, it's not going to smell any better down the road. Yes, sir.
What is the difference in responsibility of the power of attorney and executor?
Okay, well, the executor is a person who handles the stuff under the will. So that's their duty. A power of attorney is while you're alive. So most people make it the same person that while they're alive. So, the brief thing with being the executor is they typically work with the attorney to have the will admitted to probate. Then we send out a notice of probate to the different beneficiaries. The executor gets a tax ID number, opens up an estate account. The assets get liquidated or they put into the estate account. And then, once that's done, then they do a calculation how much people are getting, and then we prepare documents called release or funding bond, and the executor writes in or types in how much everyone's getting. And the form is emailed or mailed to everyone saying, listen, sign in front of a notary. Once everyone signs, we file with the surrogate and we give the money. Not that complicated. Being the power of attorney person is the person that handles your whatever really needs to be done. Yes, ma'am.
Can you set up a power of attorney that states only when you become not capable?
That was the very next line.
Okay.
That was the very next line. That's a good question, but you already got a book. So. All right, so now, having said, the power of attorney is effective either right away or only upon disability. I'd say, I recommend people make it effective right away. The reason why I recommend it be effective right away is the problem is if it's effective only upon disability, you got to get a note from the the hospital doctors, whatever, doctors, and then you go to Wells Fargo that looks at it and says no. And by the way, a lot of the banks were giving people a hard time with the power of attorney even effective right away. So the legislature came out with a law that says, listen, if it makes reference to the New Jersey statute, then the bank has to honor it. Otherwise, a complaint can be filed against them with the Department of Banking and Insurance. So, because a fellow, came in the other day, goes, yeah, the bank is giving me a hard time. He goes, what's your email? Here's the complaint. If that bank gives you a hard time, once you show them the valid power of attorney, he was showing them the living will, which is the wrong thing. But anyway, so the power of attorney is effective either right away or only upon disability. When it's effective right away, it's durable power of attorney, stays in effect if someone becomes disabled. If it's effective only upon disability, it's called the springing power of attorney. Only springs into effect if someone becomes disabled and gets a note from a doctor. Last year, client Joe goes, Kenny, listen, he goes, I'm a carpenter, I don't understand this legal stuff. Please explain to me in carpenter terms. So I goes, okay. if your son's, you want to give the power to your son. If it's effective right away, your son can steal all your money right away. If it's effective only upon disability, he has to get a note from a doctor before he steals your money. Knowing that, do you trust your son? Because I trust my son with my life. Make it effective right away, because the problem is the bank's going to give people a hard time if it's effective only. Because, oh, how do we know that the person will get better? We did a power of attorney for someone. It was kind of sad. He was missing and presumed gone. But I said for to the family, for whatever reason, Fred made it. He insisted only upon disability. Well, there's no proof he's disabled, so the bank is not going to honor. And this is but we also put in the language that banks have to honor it, but it has to make reference to Section 2 Appeal 1991C 46:2B-2, and these cheaper free things you have to find online aren't going to have that stuff. That's why I tell people it's a better idea to have it effective right away. Now, yes, ma'am.
One more.
Yeah, that's okay. I'm here to answer your questions.
The person that you want to make the power of attorney, do they have to sign
No,
anything?
no.
So you can make them have power of attorney and they don't have to know?
Well, the problem, you don't have to make them.
Until it's late.
Yeah, you don't have to make them know, but if all of a sudden you fell down and broke your crown, you're coming out of Walgreens and clunk your head on the ground, and you're in a hospital, they're going to say, does the person have a power of attorney? They're going to say, I don't know, or none that I've seen. What I've been recommending people to do is after they sign the document, the better thing to do is you can make some copies. You find one of these, kids or grandkids that has a scanner, scan it, and that way it's online. And also that you can send it to, if someone has a financial advisor or an accountant, it can also be sent email to them. That way it's there. Same thing with, I'm going to talk about living wills shortly, but the living will, it's a good idea to scan it, you email it to each other, email it to family, then email it to the doctor. That way, heaven forbid there's ever a situation where they say, does the person have a living will? I remember that I always asked that question, was, yeah, I got it on my phone. Yes, ma'am.
When the person goes into the hospital, the first thing that they would ask if they were incapacitated is, where is the power of attorney?
Well, that's and also
they have to have a written proof that they're proud power.
And the good thing is, if the power of attorney is already done, the living will's done, then the family has it. They're not as particular on the original as the surrogate has to have the original will. But again, it's we've never had anyone who did a will say afterwards, oh, I wish you didn't do that. Everyone's like, okay, I'm glad I finally did it. I'd say, Kenny, I'm glad that you kept on, you and your office kept on pestering me to get it done. I'd say, yeah, one of my elk brethren, every time I see this guy for a year, Kenny, Amy, I gotta go in and get the will done. I gotta go to his. And you're not allowed to talk to me ever again until you get the document, because this has been our main thing. We're not talking about how the Mets are doing whatever. I gotta do a will. So I mean, if you're going on vacation, you do a lot of planning and what hotel, whatever. You get the documents done. Don't be a putter off. By the way, another guy, I always, not that I go to the Elks Club every night, but they've been friends of mine. I'd see this guy periodically. He goes, Andy and I got to come and get the will done. And I knew him from high school. We all went to St. Thomas Bishop. And this guy worked for Morgan Stanley in the World Trade Center and was there the day of 9/11. The day after 9/11, he calls my office and goes, I think I should get the will done. And I go, yeah, I think you should. I'll see you. They come in Thursday. You don't have to bring me in. I'm kind of busy. Busy doing what? Cutting the grass? And this is before they had any kind of remote thing. I go, I'll see you Thursday. Otherwise, you can't talk to me anymore either. All right. So So that talks about power of attorney, the last thing, and we revise our forms each year because sometimes something comes up and it goes, oh, I should add this in. So, when they had the HIPAA law, we added that into the power of attorney. When they came up with the Designated Caregiver Act last year, we added that in. When they had the post, we added that in. I do recommend a new power of attorney be signed every 5 years. A will that you do is valid forever. But the trouble with the power of attorney is, again, the banks sometimes give people a hard time. Oh, that's 19 years old. And how do we know the person didn't do a new one? If the person you had in there changes their name, and it's probably a good idea to have a new one signed. So because someone could have one of their kids as on the person on the power of attorney. If they go to the bank and it says like Cynthia Bashensky at 24 Coolidge Avenue, and they show their ID, and it's Cynthia Voddermill that lives in Dayton, they're gonna say, who are you? Oh, that's me. You go to the bank, oh, that's me, but I changed my name and moved to. What's Wells Fargo gonna say? No. Okay, last thing before I bring up Dan Fabrizio, the Living Will Advance Directive. The Living Will Advance Directive is to avoid the situation from the Karen Ann Quinlan Terry Shabel where there was nothing in writing and you have to go in front of courts and traumatize the family, because that's really what it is. Because if it's ever been asked of you, I remember one time a doctor goes to me, because the person not have a living will, but they're the power of attorney. Should today be the day? Meaning, should we remove life support? And I remember saying to the doctor, geez, doctor, I feel bad. And the right call is for someone who's 92 years old that's never gonna open their eyes again based upon what happened to them medically. But you hate to be the one to say, yeah, do just like pull the switch today, I don't want to hang out here anymore. I couldn't even do it for my dog when my dog was so sick that we spent $16,000 on vet bills and surgery because the vets were going to magically cure the dog. And you know what? I go, let's say, the different vet, I remember asking a different vet, is the dog going to get any better? Different vet, no. No. And he goes, listen, you have a lab and it's that kind of breed that's going to try to keep running and running. It has like 2 legs, but so the idea behind a living will is so that you've made the decision so your family doesn't have to go through the trauma of being asked to make the decision there. And we took some of the language from the State Medical Society. So basically, the first section, fluids and nutritions, if you're in a coma, irreversible condition, we're talking about there's no hope for you and you can't talk anymore. Not if you happen to have a heart attack, when you're buying vegetables at ShopRite, they don't, people were afraid when they first came out, people were afraid to have it. Well, that means that they won't do anything to revive me. No. It's where the doctors already declared that there's no hope for you. Okay, so fluids and nutritions withheld or provided. Next section B, artificial machines. 99% of people say no. We also added in a medical power of attorney, the person, your captain of the ship, similar to your executor, similar to your agent in the will. And that is important also because that way you have one person that the doctor can talk to confidentially, et cetera, et cetera. And it also prevents someone who wasn't involved from walking in. Here's what happens a lot of times. The person who wasn't involved, that wasn't helping out, wasn't driving mom or grandma to the doctors, and didn't do it. All of a sudden, a different person comes in and goes, okay, I'm in charge now, and this is what we're going to do. No, you're not in charge, and the person already picked this person.
You can make that part of the regular will?
Yeah, it's part of, there's 3 documents. The will is if you die. The power of attorney is you're giving financial power to someone. The living will is where for when you're in a coma, et cetera. So we put a number 1 and number 2. They don't have to live in the U.S. And some people have someone different only because one family member may be more knowledgeable with medical stuff or whatever they did in their field. Yes, ma'am.
I was going to say, just make sure when you pick your person for the living will that they understand what you want and that they're able to stand up to physicians when they're asked questions, And that they have, it helps if they have some knowledge of medical things. It does help. But they have to be able to stand up to the medical field, because as a nurse for 50 years and a patient advocate, I've dealt with that many times, where it's all how it's presented to a family member. And if it's presented that you're killing a person, the person can't make a decision. If it's presented.
By the way, in New Jersey, just last year, they adopted the Death with Dignity Act. But ironically, the person has to be able to communicate to the physician. And it also prevents, the different states have, part of the statutes prevent patient dumping, where some family members like really sick, so they decided to drive. I think Oregon was the first state to have it. You couldn't drive to Oregon on a Friday afternoon and dump, mom or dad off and say, hey, listen, we want you to put them down right now. Oh, I got like 15 more seconds. Let me just finish up with a couple of things on this, like the power of attorney stuff. So you're like, you have someone that's there, and it's this is a good idea where you scan it, you can give it to, it's your right, you can give it to, email it to everyone, or just one person, send it to the doctors, but this way, it is there. There's no document that is ever foolproof, because you always hear stories that, the person on a living will, but the hospital wouldn't honor it. Well, the hospital also has an ethics board where sometimes they'll say, no, we think they'll be discharged in a week. We're not gonna go with the family's wishes to, quote, put them down, remove life support if we think the person would be able to be discharged in a week. And, the last thing I'll say, but you kind of want to have someone who's strong. If you say, listen, I used to say, if I can't run every day, I want to be put down like the racehorses that break their leg. I changed that the first time I was on crutches. I had to miss a day running from 1982 to 1999. And I would have ran that day if it didn't snow. I don't want to crutch in the snow. Anyway, that's it. So, you know how when you're first married, you're all lovey-dovey, and I'm redoing my documents, and my wife said, oh, I could never let them make the decision to remove life support. Fine, I'll just leave my dad in, because he's logical like Mr. Spock, Star Trek. That's what Ken wanted. We're staying with what Ken wanted. So 25 years or so later in the future, we're updating some documents because, my kids were a little bit older, and they didn't, my 24-year-old no longer needed a guardian, I think he was applying to dental schools but anyway, but it's the other way. My wife goes, wait a minute. So if you get dead, I get $850,000 tax-free, and I don't have to work another day in my life, and I can move out of New Jersey. Oh, I said, kill him now. Why wait? Put him down now. Okay. Yes, ma'am.
A couple more questions.
Oh, I'm ready.
All right, so the first one is, if you own a home with a mortgage and are unmarried, is this an asset that you leave to someone in a will?
Well, typically the will says, everything I have goes to X. Now, someone could say, any interest I have in a house goes to whatever. Obviously, now, if someone's just leaving the house and there's a mortgage, they either got to pay or the house gets foreclosed on. Right? Next question.
All right. If the person passed with no will, who would get their vehicles, the spouse, an NJMV surrogate certificate, what information is required, or do they need to change the title registration?
Let's say, well, if there's no will, you got to get paperwork from the surrogate, if there's a spouse, to be, now there's a thing that the surrogate has that they call we call it little estates. They have a legal term for it, but it's for estates under 50 grand, where the spouse can say, listen, everything's going to me because it's under 50 grand, and just give you the papers, and then they got to fill out whatever forms of motor vehicles. I've been blessed I never had to do it. But Next question.
Can you suggest, what we are to do in the instance where my uncle has a will but does not have a power of attorney and has dementia? Can only his son make decisions on his behalf?
If someone does not have a power of attorney, then they don't have any legal representative for them. So in the cases where someone, we get the calls, okay, I need to get power of attorney over mom, dad, Uncle Joe. Okay, can they talk to us to say what they want? No. Okay, then we can't do the power of attorney. The only alternative is to do nothing, wait for him to pass, or go through this expensive, complicated procedure called the guardianship, where you're asking the court to declare a temporary guardian for them, a law guardian, and then have the court declare the person incapacitated and have a family member come in. And it's a very sad thing because you kind of have to air your dirty laundry, like before COVID, in the whole full courtroom of people to say, talk about, how, moms, or whatever family member, is like, is soiled, whatever. It's very sad. So that's why you do have the power of attorney to avoid that kind of stuff. But the government doesn't do it. Any other questions? Okay.
I have one more.
Oh, yes, ma'am.
Is advance directive the same as the living will?
Yeah,
Is it the same?
I use the term living will goes off my tongue easier than advance directive for healthcare with medical proxy. So I just used the generic term living will. Okay. I'll say goodbye. Bye. Okay, Dan.
I won't be long.
Tell them, like, what suggestions you have for people that so they don't ruin their finances.
Good evening. My name is Dan Fabrizio. I'm a financial advisor for New York Life. A little about me, I worked on Wall Street for 22 years where institutional investors were my clients. Now I work on Main Street where individuals like yourselves are my clients. And tonight I just want to talk about 7 common retirement mistakes as people are either in retirement or near retirement. So a couple of items. Number 1, not planning your retirement with your life expectancy in mind. How old are you going to live? How long? People today live longer than they did 30 years ago. All right. So the reality is the expectancies are increasing more than they were ever before due to medical advances and medication. The important part is to rely on data and not so much on how old your parents lived or your grandparents lived. Okay. There's nothing deterministic about your life expectancies estimates, so just be careful when you plan your future, what you realistically feel you're going to live to. Number 2, not being smart about claiming Social Security. Some people are still taking Social Security before they attain age 65. Okay, you're going to get a smaller check for the rest of your life. If you have the financial resources, and let me go back a step. Maybe they need the check and money, and that is all they have, and that's why they did that. But generally speaking, if you can wait to 65, you're fully vested at the retirement age, and you'll get a check, that check for the rest of your life. If you have the financial resources and can stay to 70, or wait to the age of 70 before you claim Social Security, your check will be about 38% more, and you'll get that higher check for the rest of your life. So going back, if you're going to live longer and you have the financial resources, it might be worthwhile. And there's actually some websites that you can go to figure out your payment, what you're going to get, and what your break-even point is. They can figure out how much you put into Social Security throughout your whole life, and at what age, when you start collecting, how old will I be when I get all my money back? And then, of course, everything beyond that is gravy. So just something to keep in mind. Number 3, taking a lump sum pension could lead to expensive mistakes. But thanks to annuities, retirees can meet their retirement goals with a guaranteed lifetime income stream very similar to a pension if getting a lump sum is your only option. Obviously, that is always the better thing. If you can get a pension or a 401k, it'll give you an income stream for the rest of your life. Number 4, too much risk in your investments at 1 year's retirement. Over the last few years, as people were getting older and the stock market was doing good, everyone put all their money into the S&P 500 and the equities, and great. And then all of a sudden, a year or two ago, boom, everyone's 401k turned into a 201k. Well, not so bad, but we're coming into turbulent times right now. So there's the recession they're talking about, inflation is out the wazoo. And I also read today that within the next couple of days, gasoline prices in the state of New Jersey are going to rise about 40 cents. So fill up tomorrow.
I filled up today.
Sorry, I don't mean to be a buzzkill, but putting too much risk in your investments as you get near retirement is not wise. Be safe, take the guaranteed, maybe 3%, 5% investment. And you may not get to 15 or so, but you don't need that risk. You need a guarantee that you're at least going to get something, but make sure there's a break where it doesn't go into the negative. And you lose money as you're going into retirement. I have a guy, he's 80 years old. He's afraid to get out of it now because he's going to lose his money. But he has obviously the financial means, but he has a substantial amount of money. And even his bonds, he's a bond guy. The bonds went down. So he's very, very like, why didn't I do this a year or two ago? So these are live examples to my experience and dealing with this. And number 5, buying life insurance as an employee benefit. While it's generally less expensive to take up the group term life insurance from your employer, whether you're a public employer or a private employer, it's great, it's a lot of coverage, it's fairly inexpensive. That coverage goes away when you leave the company or you retire. The benefit is try to get an outside policy outside of your work to coincide with your work. And generally, if you're age 50 and over, there still are some coverage options available, final expense policies, but it's not till after you retire and you're above 50 or maybe 60 and you start thinking about this. Remember, insurance is based on 3 factors: your age, your gender, and your health. And you can't control 2 of them. So just keep that in mind. Number 6, focus on assets over income. One mistake I've seen is switching your mindset from saving and saving and saving your whole lifetime until like, well, now I got it. How do I spend it? Do you pull out of your retirement 5% a year, 4% a year, 6%, and being sure that's going to last you your lifetime? There's a lot of questions that come into play. So if you have a lifetime pension or a lifetime annuity, at least you have that income stream, and in addition to your Social Security. But there are those that maybe just have a 401k or 403b or 427. That has limitations of how long is that going to last unless it's a substantial amount of money, as well as everyone's price of living. What does that mean exactly? So speak to a financial planner to help you figure out that part. And the final item I want to touch base on are bank CDs. Older adults, when they retire, store large amounts of money into bank CDs. They've been putting money aside, and all of a sudden, they're putting that money into bank CDs for maybe 3 years, long-term CDs they're called. The downside of that is you can't touch that money. Well, besides you're going to get a horrible interest rate. They have been horrible for the last decade or so. Number 2, you're going to get a 1099 at the end of the year. So you got to pay taxes on that interest, but you can't spend that interest. And number 3, if you pull that money out for an emergency, the bank's going to penalize you and take 10% of that. All right? One of the other options I like to share with people are annuities that insurance companies have that compete with the bank CDs. They last 3 years at a minimum. Your interest that you earn is tax deferred. You won't get a 1099. And they have liquidity. If you need to take out 10%, there's no penalty. And they also, at year number 2, you can take out all your money and there's no penalty. So there's more flexibility, including with a high interest rate. Actually, I left a flyer over there that it's like up to 3%, 3.1% now, where banks are offering, I think the most is 0.9% right now. for a 3-year CD. So we compete one-on-one with the banks on that. 5 simple tips in retirement. Know your monthly number. How much do I need to live? What are my expenses gonna be going into retirement? Number 2, make a plan for Social Security. Know what you want, know when you're gonna start taking it, and I touched that about. Think long-term about taxes. Right now, we're actually living in a very low tax environment. If you look at the last 50 years of federal income taxes, they were killed a long time ago. We're at an all-time low right now. Think about that. Think about it's going to go up in the future and how you're going to be taxed on that. Think about adding another lifetime income stream. You could take a 401k and you have $100,000 and you're 70 years old and you have to live on that, on top of your Social Security. You can roll that into a guaranteed lifetime income annuity and you'll get a check for the rest of your life. That's how you create another income stream. Plan for both spouses, not just for yourself. And those are the little tidbits I have. If anyone has any questions, I have these little information cards, just fill it out and leave it for me, I'll reach out to you. But I'm licensed in New York, New Jersey, Pennsylvania. I do life insurance, I do long-term care insurance, I do retirement planning, I do annuities. What else do? I do brokerage, help people kind of figure out what they have. And like Ken, I do free consultation, there's no fee. If you're in a 401k, you don't know how you're allocated, I kind of help you out and just give you some guidance on that. And that's pretty much all I have. I don't think anyone has any questions for me Facebook land. Thank you very much for your time, everybody.
Very good,
Thank you everyone on TV land and the 50 or 60 people in the room. Have a good evening.
Thank you.
Abrams.